Okay, so we're back. And so now we're going to have branding yourself in today's market, learn why your brand matters and how to make it grow. And the moderator for that is Scott Baldwin, and so here is Scott.
All right, thanks, Dennis. Okay, thanks initially to Dara and Lindsay for getting the energy up. That's good. Hopefully we can continue that in our next panel. Because our next discussion is on something really important. And it's important because every single one of you guys is going to have one or more of these trademark things, these brands. So it's really important that you have a flavor for what they are, how the system for protecting them works, and how you guys can grow and protect great brands. Okay? So let's kick it off. The way we're going to run our panel today is I'm going to introduce everybody. Each of the panelists will give you sort of their opening nugget, a useful nugget that they want you to know. And then they made it clear that they wanted you guys to get an opportunity to give as many questions to us as you can. Okay, so after their presentations, their opening remarks, we're going to open it up for questions from you guys. So while they're speaking, start thinking of questions that you have about trademarks of brands. What makes a good brand if you have a brand already? That sort of thing, so you can get some questions from these experts. Okay, so let's kick it off. First person I'll introduce is Stephen Heller. He has degrees in both law and accounting, and he has 25 years of licensing and business development experience, and he used that to create his own licensing brand management company called the Brand Liaison. Over the years, he's worked with companies you might have heard of: Disney, MGM, the NFL, NBA, Target, and Walmart. And you even heard from Lindsay and Dara that they even know him, so he's well known in the industry. Steve is also a frequent public speaker and a professor of business and law. Our next speaker is Craig Morris, a friend of mine I've worked with a lot over the years. He is with the USPTO. He's our managing attorney for trademark outreach, where he goes out around the United States and helps educate independent inventors and small businesses about the system for protecting trademarks in the US. And gives them information to help them select and protect great trademarks. And our last panelist is Mahe Rangareddy. He is the Chief Financial Officer and Chief Technology Officer of Alpha Omega Integration, systems integrator servicing both the federal and commercial customers. And as part of his job, he focuses on building the corporate brand through both traditional and digital techniques. And so that's what we're going to talk about, branding yourself in today's market, how to select and protect great brands. Okay, so let's kick it off. I'll start off with Steve.
Thanks. Thank you. Before we start, I just want to tell a quick funny story about branding, and it's actually a true story. It happened to me about a year ago. I was working on my computer, and I get an instant message, a DM pops up on LinkedIn, by the way, from a complete stranger. And a message pops up, and I turn my attention away, and it starts off, "Excuse me, sir." So already I know I'm in trouble. Starts off, "Excuse me, sir, can you please tell me in some simplified form?" Then he opens parens and says, "Approximately 50 words or less should do." So he's going to ask me something, and now he's telling me how he wants me to answer it. "Excuse me, sir, can you please tell me in some simplified form, 50 words or less should do, how does one go about building a brand?" This is from a complete stranger asking me now to teach him how to go about building his brand. So I have a personal practice of always trying to respond to every email. So I thought about it for a second, and I wrote back, one, there probably isn't a single answer. If there was, it surely wouldn't be 50 words or less, but could be textbooks on textbooks on textbooks. 3, companies hire entire teams, agencies, consultants, pay hundreds of thousands or millions of dollars to figure this out. And 4, they probably only get it right about half the time. But if I did know the answer, and I could articulate it in 50 words or less, you wouldn't find me on LinkedIn. I'd be off on a yacht somewhere. And then I wrote, and by the way, that response was 49 words. But it got me thinking, how does one go about building a brand? what is a brand? So I Googled, what is a brand? I started doing some research. And the first thing I found was Merriam-Webster's dictionary told me that a brand is a class of goods identified by the name as the product of a single firm or manufacturer, as in a brand name. And similarly, the American Marketing Association had a similar definition. They said a brand is a name, a design, a symbol that identifies one seller's goods as distinct from another. Now, those definitions sound a lot like the definition of a trademark. But that can't be right. A brand is much more than just a trademark. Yeah, a brand distinguishes one seller from another, but it's got to be more than that. So I found Marty Neumeyer. He's a speaker on all things brand. He should know what a brand is. Marty Neumeyer starts off by actually telling me what a brand is not. And he says, a brand is not a logo, a brand is not an identity. I'm like, wait. The American Marketing Association just told me that's what it was. He says it's not that. He then goes on to say a brand is a person's gut feeling about a product. Well, I have a lot of gut feelings. Sometimes I don't even feel good. That can't be what a brand is. Then I found David Ogilvy, the father of advertising. And he gives us a very complicated definition saying, a brand is defined as the intangible sum of a product's attributes, its name, its packaging, its price, its history, its reputation, and the way it's advertised. Okay. I found a business dictionary that gave me a 2-sentence definition saying that a brand is a unique design or symbol creating an image that identifies a product and differentiates it from its competitors. And over time, this image becomes associated with a level of credibility, quality, and satisfaction in the consumer's mind. Now it's starting to get somewhere. It creates an image, over time, a level of satisfaction, consumer's mind. But it occurred to me at that moment, maybe there isn't a single definition of brand. Because as I learned in just 5 minutes of research, a lot of people have a lot of different definitions for brand. So I thought about, well, how would I define brand? And I couldn't do it. I feel like I know what it is, and I couldn't define brand. And for me, a type A personality, that was very frustrating. I say to myself, I'm a branding guy. I've been around brands my whole life. How can I not be able to define brand? And when I said that to myself, I've been around brands my whole life, a light bulb went off. Instead of trying to define brand, why don't I list a bunch of brands and just see what they mean to me? So I took out my pen and my pad. I took out my Bic pen and my Mead 5-star notebook. You see where I'm going, right? I took out my pen and my pad. I looked down and I wrote Nike sneakers. Then I wrote Converse and Gucci and Prada, Timberland, and Keds. Then I looked at my Bic pen, I wrote Bic pen, then I wrote Mont Blanc pen, and Cross pen. Then I thought about cars, and I wrote BMW, and Porsche, and Mercedes, and then Toyota, and Kia, and Hyundai. Then I wrote Rolls-Royce, and added Scion. Then I looked at my Rolex watch, and realized I don't have one. But I wrote Rolex down anyway. I wrote Swatch and Fossil, and then I wrote Fitbit. I wrote down McDonald's and Taco Bell and Subway. Then I wrote Ruth Chris Steakhouse and Morton's, Applebee's and TGI Fridays. Then I wrote down Swanson TV Dinner, SpaghettiOs, Del Monte Vegetables and Dole Fruit. And then I almost got off on a tangent. I started writing Raisin Bran and Frosted Flakes and Mini Wheats, and I had to stop. I could have written 100 cold cereals. But as I read over that list a couple of times, I felt the feelings inside me change. Did you guys feel that when I was reading those names? When I said Nike, Converse, then I said Prada and Timberland, or when I said Taco Bell and Subway and Ruth Chris and Morton's Steakhouse, did you feel those emotions changed? And that's what it occurred to me, that's what a brand is. A brand is that emotional feeling that you get from thinking about using or thinking about that product. What people think about your brand, or more accurately, how they feel. So David Ogilvy was right when he said a brand is an accumulation of all of those attributes, but not just price and packaging, a holistic approach of all of the emotion when you use the product. And that's what Marty Neumeier was saying when he said it's a person's gut feelings about a product. And that business dictionary that said it becomes associated with a level of satisfaction in your mind. You see, a brand is much more than the Merriam-Webster dictionary of a brand name. That's your trademark. That's what you file with the US Patent and Trademark Office to distinguish your product and service from another. But to build a brand, you have to create that emotional bond with your customer. See, a trademark is objective. It's a word, it's in a book, it's on file, it has a number. But a brand is subjective. It's a feeling and it's an emotion. And that's what all those scholars were saying. To have a brand, you have to have that emotional bond between a company and its customer. And that's why I threw in the Swanson TV dinner, because that's a nostalgic brand that means something to me. It reminds me when I was 11 years old, on nights when my mom had to work late, and I ate that delicious turkey and stuffing out of a little tinfoil tray. And then it occurred to me that it's really easy to answer that first gentleman's question, how does one go about building a brand? All you need to do is create that emotional bond, do things that create that emotion, and just repeat it over and over and over. Thank you.
See, told you he was great. Okay, next we'll keep it going with Craig Morris.
So how should we think about trademarks as related to brands? Well, one way to think is perhaps that they are brothers. They are part of the same family, they are related, but they are not identical twins. You should not try to use the word brand and trademark interchangeably because, as we just heard, they clearly are different. If you view the brand as the reputation, the trademark is the way that you legally protect that reputation, that you establish that you have actual rights that are unique and specific to you for your product or your business. That is the role of the United States Patent and Trademark Office that Scott and I are from, to assure that any mark that is to serve that function, to be a source identifier, that it is then registrable. That is the mission of the USPTO, to register any mark that is in fact eligible for registration. So let's just recap the classic definition of a trademark. It's any word, it's any symbol, it's any design, it's any combination of those things that distinguish the goods of one company from the goods of another company. Now, right off the bat, you might be thinking, well, what if I don't have goods? I don't have a product, I offer a service. Then technically you have what is known as a service mark. Trademark for goods, service mark for services. But beyond that difference in naming, they basically serve the same function, to be a source identifier. Now you may see those symbols. How do those fit in? The TM, the SM, the R in a circle. Well, the TM or the SM simply means you have adopted that wording or that design as your trademark or service mark. You all could leave here today and start using that TM or SM symbol. Doesn't mean that you've even applied to the USPTO to seek registration. You have simply adopted that as your mark, and you are entitled to use the designation of TM or SM. Put the public on notice. This is my trademark or my service mark. The only thing that you are not to do is use the R in a circle symbol. That says that you actually applied to the USPTO and were successful and you've been granted a federal registration. Now, not all marks are in fact eligible to register. Not all marks are legally protectable. Always remember, you are not buying a trademark. You are applying to seek federal registration. You don't get your money back. That filing fee covers our process to review your application. So rather than simply jumping in, you should probably do some thoughtful research to make sure that you come up with a mark that is in fact going to be registrable. One of the first things to worry about is to make sure that you are not adopting a mark that will be confused with another party's mark, what we call a likelihood of confusion in the marketplace. The other thing you want to make sure is that you are adopting a strong mark. Some marks are strong, other marks are weak. Strong marks are marks such as Xerox or Kodak, created specifically to serve the function of being a source identifier. Marks that are weak are marks that usually are descriptive marks. They merely describe a characteristic, a quality, a function of the goods or services. That's really one of the mistakes that most people make when starting out, because they work with a marketing professional. Marketing people love descriptive marks. The marketing person will tell you, you will not have to spend as much time or money enticing your consumer to buy your product or use your service, because that enticement comes from the mark itself. Always remember that trademarks are legal things. Ideally, legal and marketing work hand in hand. So you don't want to adopt a mark that simply sounds like it's a good mark. You want to make sure, again, to do the homework, to make sure that there's no confusion in the marketplace, and then at a minimum, your mark is either fanciful or arbitrary or maybe suggestive, but you don't want to have a mark that is simply going to be viewed as merely descriptive, because that mark will not serve the function that it needs to in the marketplace. Again, to distinguish your goods from those of another party, to make sure that there's no confusion. The last category, and I think we might hear a little bit from our next panelist on this, is generic marks. Generic marks are marks, they're not even trademarks. They're the actual name for the product or service. That would be, for example, if you're coming up with a new dairy-based beverage, you really couldn't say, and my trademark is milk. Unfortunately, good trademarks, through misuse over time, they slide into that generic category. Aspirin, zipper, escalator, thermos, at one time they were all registered marks in the United States, but through misuse over time, they became generic. So if you have a good trademark, you want to make sure you're using it in the manner of a trademark so it does not slide into that generic category.
Okay. All right, so we're going to wrap it up. Thank you, Craig. So I'll just remind you, as we're going through these opening remarks by our panelists, I want you guys to all be thinking about your questions, because like I said at the beginning, this is not like a hypothetical for you guys. Every single invention, once it gets out of the lab or out of your garage even, is going to be sold under one or more of these trademark things that will hopefully eventually become a brand, as Steve was telling us. Okay, so every single one of you guys, I saw a lot of hands earlier this morning about people who already have patents. You got to think about it. Every single one of you guys is going to have one or more of these things. And trademarks are not all created equal, as you heard from Craig. Some are better than others. Some are stronger than others. And that's what you guys want to. That's what you guys want to have: the best protection for your brand that you can have. Okay. Okay. So with that, I'll turn it over to Mahe, our next panelist.
Good morning, everyone.
Morning.
Thanks, Stephen, for a very good introduction about brand, and Craig for talking about generics. Today I'm going to talk about three things. What is a brand? I'm going to summarize. I'm not going to go into detail, as Stephen covered very nicely. I'm going to talk about my personal story, which happened in my childhood when I was 5 years, about 4 decades ago. And the last thing I'm going to share is it happened like a few minutes ago when I was driving to conference. I was talking to my dad. The first thing, what is brand? Brand, from my perspective, is what everyone, like your customers, speak about it when you are not around. they have to speak about it when you are not around. So it applies to both you and your product, right? It's what people speak of behind my back is brand Mahe, and the same applies to any brand. It doesn't matter how many emails you send to your customer unless customers speak about you. So there are many channels today, whether it's Instagram, WhatsApp is a new channel, Facebook, all other social media channels you have, but it does matter only when your customer speaks. That's exactly what Stephen completed his conversation is, brand needs to be emotionally connected. That's very important. If a customer is not emotionally connected to your brand, then they won't speak about your brand. So that's the key. The story I want to share is when I was 5 years old, or even around that time, we moved from a city to a very rural, my dad got transferred, so we went to a rural area. My mom, one day, we ran out of toothpaste, so she said, can you go to the store at the corner of the street? It's a mom and pop store. No Amazons, no Targets, or no Walmarts. Then this is in India, back in India. So I go to the store. My mom said, can you go get Colgate? She actually meant brand, Colgate. So I went to this small store and I said, brother, can you give me a Colgate, and here's the money, right? So I give him the money, I get whatever he gave to me, I take it back home. My mom sees it and it's like, I asked you to bring Colgate. Why are you bringing me this one? I said, this is what the storekeeper gave me. So she said, no, go tell him that you need a Colgate. So I go back to him. I go tell him I need a Colgate. So he thought I'm asking for some other brand. So he gave me another box of a toothpaste. So I brought it back home. My mom was really furious this time. She basically said, I asked you to bring Colgate, why are you bringing me some other brands? So she holds my hand, drags me to the store. She's furious, she goes burst. Like, I am asking you for a Colgate. You're cheating my son by giving him different brands. So the storekeeper says, ma'am, please wait. He goes inside the store, brings all the brands he has and says, puts in front, these are the Colgates I have in my store. So the story here is that now a brand has become a generic. From the storekeeper's perspective, he is talking about a toothpaste which he knows by Colgate. From my mom's perspective, she wants a brand. She is emotionally connected to Colgate. That is why she couldn't go and get any other, she couldn't take any other brand. Right? She wants Colgate, whereas the storekeeper, it has become a generic. So that's the impact of a good brand, right? So, and we can go on and on. What Clorox did for wipes, what Xerox did for photocopy. That being said, I was driving today morning. My dad called me. I didn't call him for last 2 days because I was on international flight, and then we didn't connect. I make sure I talk to my dad, who's in India, at least once a day. So he's 75 years. He was a retired professor, and he was also an international consultant on bird aviation and other things. So he called me, and I was talking to him and said, where are you heading to? I said, I'm driving, I'm going to a conference, I'm going to speak. He said, what's the conference about? I said, about branding, and it's a USPTO conference. It's about a lot of innovators will be there, and he is also an innovator. He has few aviation strains in his names. And I was talking to him, and I said, why don't I ask him what brand is? So I was actually having to speak about a different quote I got from Google, but I have to replace it with my dad's quote. He said, brand is the business card, and not your business cards you carry with you with the brand. That actually was very impactful. I was reflecting on it after I spoke to him. It's a lot. We have to get to that point where your brand becomes a business card. You have to work hard. But once you get to that point, like IBM's, Nike's, Converse's, or any other, in fact, US government is a brand by itself. So anything you do, you need to make that impact. And the way you could make that impact is by emotionally connecting. And how would you emotionally connect is by understanding your customer. And everything else will fall in place. Thank you.
All right. All right. Thank you, guys. Now we wanted to open it up to you guys, to let's hear from you about your questions, about your experience or what you're thinking about doing about selecting and protecting your brand for your invention or your small business or whatever it is. So let's take our first one.
Yeah, Daniel from Las Vegas. Question, why did the trademark department approve Radio Shack's trademark? They put the R off-center inside of the circle, which I find so close to the registered symbol. Why would they approve that?
It's all you, Scott.
All right. Okay, not exactly what we were expecting for questions. I haven't looked at Radio Shack's registration, but I get from your question that you're saying it looks too close to the registered trademark symbol.
The registered trademark, the R is centered inside of the circle.
Yeah.
But theirs is off-center.
I guess the examiner, when they were examining that, thought it was different enough from the circle R, which is what Craig was talking about, which denotes a registered trademark, which is different from the TM and the SM. So that's the only thing, without looking at it more closely, that's what I can think, is that it was just off enough that it was not determined to be the same as our registered symbol, and it was not going to confuse people or cause any sort of deception.
Also, I would guess that the location of using the circle in the R as part of the logo wasn't in the same place where you would recognize it in the upper right-hand corner, traditionally, of where registered marks are filed. So I don't know that there's any prohibition against using R's and circles in general, but not at the end of the mark where you would be misleading consumers to believe that this mark was formally registered.
Thank you.
Okay, we got one in the back.
Well,
Yeah, if you raise your hand, we've got people with mics that can bring them around to you. So just raise your hand.
since Radio Shack is out of business, isn't this discussion kind of moot?
Maybe. Unless anybody here is really looking to trademark Radio Shack, I think it's moot anyway. But okay, next questions.
Hi, good morning. My name is Raghu and I'm from Maryland. I had a question about trademarks. Is trademark always a visual cue, or can it be something three-dimensional or non-visual cue like sound or something else?
Right,
A three-dimensional object?
Yeah. So I gave the traditional definition of a trademark. It's a word, a symbol, a design, but it's really anything that can serve the function of being a source identifier. So color can be a mark, sound can be a mark, smell can be a mark. And you're thinking, well, wait a minute. We recently registered the scent of Play-Doh. Remember Play-Doh when you were a kid? It has a very distinctive smell that is now registered as a trademark. Holograms are registered. So here in the office, we never thought years ago that we would see certain categories of marks. Lo and behold, someone filed, and we said, it serves the function. We're now waiting for that next filing to say, here's something totally new, yet it qualifies as a trademark.
With that being said, anything that is a source indicator can be protected as a trademark. Now, there are a lot of extra considerations that go into figuring out whether or not a sound or a color or a smell can be registered. Just because they're eligible doesn't mean every single color. There's a lot more steps and analysis that have to go into proving that consumers recognize them. They stop seeing them as just a color or a sound or a smell, and they start recognizing them as a trademark. So just keep that in mind. Not every single color, sound, or smell is going to be protectable initially.
I think just a few examples of these. The silver wrapper on the Polar ice cream bar. I think that's a color mark, and sound of Harley Davidson I know is a famous sound that's a trademark, including the roar of the MGM lion. So these are examples
Well,
of...
I'll have to jump in there.
Go ahead, sorry.
Only because, yes, Harley-Davidson did file to register that sound, and they spent 6 years trying to get it registered. They ultimately were not successful. Going to Scott's point that not every mark will register, but yeah, the other example, MGM, the lion roaring, certainly a registered sound mark.
Yes, we have a question up here after this one. Okay, we have one. Okay, we'll get to you. Go ahead. Up back.
Okay. I've gone on the site, USTPO, to look at trademarks, and I wondered, when it says expired, that means it's good to use again, and also, say the trademark is cupcake, and I don't want to do it in a bakery business, I want to do it with lipsticks. So can cupcake then be used if it's a completely different area? And if it says it's expired, can you go with it even if it was in the same area, if I made sense?
Okay, so within our database that's accessible from the website, what you're referring to is there's an indicator whether that particular mark is live or dead. Be very careful if you see that it is dead. That means that the actual prosecution at the USPTO has ended. Contrasted with, someone could still be using the mark. They could have what we call common law rights. Just because it is dead at the USPTO does not necessarily mean that someone is not still using the mark. So you have to be very careful. Do not automatically assume, oh, this is eligible for me to adopt it because I see it's dead. You have to find out, has the use totally stopped? Then the second part of your question, cupcake, obviously generic if you are selling cupcakes, so that would never be registrable. But if you're using that word, prime example, Apple. Well, Apple selling apples, no good, except Apple for computers, now one of the strongest trademarks in the world.
But could you sell Apple hamburgers?
Only if it would be deemed to be deceptive in some way. I think you said Apple hamburgers.
Yeah, so it's a completely different product line.
Well, it's a different...
But it's a famous name.
Right, so in terms of the likelihood of confusion analysis, twofold: are the marks confusingly similar, and are the goods or services somehow related? Identical trademarks can coexist in the marketplace, no relationship. Dove for a bar of soap, Dove for an ice cream bar, identical trademark, still problematic? No, because those goods simply not related.
But I'm glad you brought up that thing about checking our register. That trips up a lot of people when they are figuring out whether or not a brand or a trademark is available for them. They'll check our register, see this expired or dead thing, and think it's available for use. No, registration with us is optional. You don't have to register. Basically, if you see something that you want to use that's dead on a register, you still have to do some additional homework. That's why we give you the name and address of the company that registered it, and you got to do some homework on the internet to see if that company is still live. Now, if they've abandoned it, then the trademark goes away, if you're not using a trademark anymore. But you need to do that not only for the thing listed on our register, you want to know if anybody else out around there in the country is using it, because that's where that common law stuff kicks up. That's what the TM and the SM is. And so if somebody has adopted that mark that you're thinking about adopting for goods and services that are similar to what your new invention is, then it could still cause some common law problems, because they could have common law trademark rights in whatever geographic area that they're doing business, and they can sue for infringement in that geographic area. Okay, so
and just one follow-up, you're thinking, well, then why would it be dead in our database? We have certain filings that are required at certain times. If you miss a statutory deadline in your filing, we have no choice but to cancel that registration, not because it's not still being used, but because the required filing was not made. That's why it's dead in our database, but could still be in use in the marketplace.
They could have just forgotten. Okay.
Just to add to it quickly, when you're trying to use any other brand or trademarks that are expired, like a good example would be Circuit City, right? You want to make sure you do the research from a branding perspective. You want to ensure that they have not left a bad taste for the consumers, so you don't accidentally pick those up, and it could impact your journey. So you want to make sure you do that due diligence. So research is very key for brand improvement.
Okay.
So what happens if you have a business and you create your own trademark, another business in a different state has their own trademark, it's the same duplication, and now you're interested in registering your trademark? What can you do then?
You want me to take it?
I can hear the first part of what
Oh,
you were
okay.
saying.
So the question is, if you have a business and you're running it under a trademark, but somebody else in a different part of the country is running the same or similar business under the same or similar mark, what do you do in that situation?
Okay, so in terms of the USPTO, what we are doing is giving federal registrations. You register at the USPTO, and you have then protection in all 50 states and our US territories, okay? But if you're talking about common law use in California and you're using the mark in Maine, they coexist because there's no crossover in the common law. That's one of the advantages of having a federal registration. As Scott mentioned, common law rights are based on the geographic area of use, whereas federal registration gives you rights in the entire country. So there may or may not be a problem depending, is there in fact some sort of overlay in terms of consumers being confused because of the closeness of the market potentially. But otherwise they simply coexist.
So right now, both of you guys have common law rights in the geographic area that you're selling, and you can sue if somebody comes into that. What happens sometimes is we do have what's called a concurrent use registration, where somebody applies, the person with pre-existing common law rights in a certain part of the area challenges it, and what happens is you'll get a registration that covers the rest of the US except for that part that the other person has. It gets more complicated. I wouldn't suggest navigating that yourself. If you do have a situation like that, I would talk to a trademark attorney to help you navigate that situation. But that's one of the great benefits of picking a good, strong mark right from the beginning and screening and clearing it to make sure nobody else is using something similar. Because the stronger your mark is, it's much less likely, 10 minutes, okay, that you're going to be stepping on somebody else's. And you do that, you screen it on the internet. You know, the more unusual or unique your mark is, generally the better. You know, like Exxon, Google, Kodak, those words have no meaning in the English language. So they're awesome for trademarks because the odds of you running into somebody else using it is low, and odds of somebody else using it on a product or service that's similar to yours is also very low. So let's go, next question. We're going to get you, I promise.
Good morning. My name is Michael Greenberg, and I'm actually a patent attorney, so I guess this question is mostly for Stephen, because I don't do trademarks a whole lot, even though I know them. So a lot of times I'll talk to regular Joe inventors, and they'll say, hey, I have this new idea, and then they'll want to pick a trademark, and of course, like you said, they'll pick a descriptive kind of mark, or marketing guys have told them to do that. And those are the easiest ones to make people remember, and suggestive ones are a little harder. Abstract ones are almost impossible because they don't have a marketing budget. Is there any general advice that you would give the average Joe who has an idea, who's maybe using pro bono patent services or using an attorney, but he can hardly afford the attorney? How can he, because he doesn't have the money to do huge surveys to realize what brand is going to make somebody feel something, what advice could you give him to help him select maybe a mark that is not going to be a fortune for him to try to market or to try to establish, but at the same time is going to stick in somebody's head? Is there any general thoughts you have on that?
One possible way of answering this, if I understand the situation correctly, is he can still create a unique trademark that may not be indicative or descriptive of the product. So come up with that unique, fanciful, or arbitrary mark, but then use a very descriptive, what I'll call a tagline, that wouldn't necessarily be registerable because it's going to use, let's just, I'm making up a silly example, but if it's a great kind of jewelry cleaner, so you couldn't call it jewelry cleaner because that's very descriptive of exactly what it does. But if he named it Greenberg's, the best jewelry cleaner on earth or something like that, then using that following tagline and always using it together, maybe even I always think back to the tagline. I think ultimately they may have even trademarked "Nobody beats the Whiz" was a electronics chain, and they always said "Nobody beats the Whiz." Nobody, it wasn't even called the Whiz anymore. It's almost referred to as "Nobody beats the Whiz." So use a descriptive tagline and always use it together. So on his business cards, on his marketing materials, on his website, it always says, and then they would become synonymous with each other.
I agree with that too. Sometimes the term I use is a good strong anchor term.
Great.
And then descriptive wording after it, like Exxon Oil Company, Apple Computers, because everybody wants to let people know what the product or service is, especially if it's a disruptive invention or something brand new. You definitely want to let people know what your stuff is. But there are a lot of benefits that come from having a good strong anchor term in your mark. So yes, I promised you. Now this guy's first.
One, then one more.
Two-part question. First of all, when I apply for my patent, can I at the same time apply for trademark, even if it is not yet in the market, even if I don't have a patent? And what stage I can go for trademark? That is first part. Second part, do we have anything like PCT that for utility patent that I can apply overseas? Do we have similar thing for trademark?
Okay, so the first question, when do you actually file for your trademark? Well, it used to be you had to have already been using the mark in interstate commerce. The rest of the world was under a different system known as intent to use. And in the late 1990s, USPTO, we changed our rules of practice to allow you to file based on a bona fide intent to use the mark in the future. You haven't actually used it yet, but you have a bona fide intent to do so in the future, so you are allowed to make your filing today, and then later on you will still have to show us that you have in fact started actual use. In terms of the international arena, always remember that every country in the world has their own trademark office. And so you have to be dealing with that specific office, but we do have something, the buzzword is Madrid Protocol. Okay, that's a system that allows you to file based on your US application. You file through the Madrid Protocol. You're asking to extend protection to other countries in the world. It's kind of a mechanism to get that application to the national office in France, for example. So go to our website, front page, search box, use the terms Madrid Protocol. That will help you get information that would be relevant to the second part of your question.
It does have some similarities to PCT. It's a streamlined way to get your application to all those countries. It's almost like a shopping list. You can check off all the different countries and it just shoots off your application. But like Craig said, they're still examined under the national laws of those countries.
Yeah, each country still approves it separately. In fact, I think Burger King has to use a different name in another country because someone previously had Burger King. So it's Jack's Burgers in Australia, but you still go there and get the Whopper. So.
Okay, your previous answers about the descriptive tagline were helpful, and this kind of follows in with this question. Is there any thoughts on balancing making a trademark name that's too abstract and a little bit too absurd, and or just absurd enough, in the sense of it's not descriptive?
Well, I think the answer is no. Again, when someone came up with Xerox, no one had ever heard of it. Kodak, it was actually George Eastman himself who came up with the mark Kodak. He thought that just sounded like a very strong mark, so it was adopted. You always run the risk of someone saying, what Scott indicated, but no one's going to know what that product is, okay? Well, then if you're concerned about that, what Scott said, you have the anchor of the other word there. So, it becomes Kodak cameras. So yeah, you still know, but the real strong part of that is the part that was made up.
What I always suggest is spend some time thinking about what's going to look cool on your business cards, on your T-shirts for your company, on your website. I always say don't just cover your eyes and start hitting a string of letters on the keyboard or something like that, because that would be probably what you're talking about to the other extreme, just having a string of nonsensical letters. But yes, think of something that looks cool and memorable. And like I said, trademarks don't have a lifespan; they go on forever. So spend a lot of time up front thinking about what's a good one and something you want to stick with forever. Okay, I think, are we done, Dennis, with time?
I think there was one more in the back. She has one.
All right, Dennis is going to yell at you, but let's take it.
My question is that company names are registered in statewide in US. So a company name, let's say so-and-so is registered in Ohio, but in California, somebody can start a so-and-so company. The question is, if I apply a trademark so-and-so with the words, would that prevent that company being registered in another state?
Always remember there is the state registration system and there is the federal registration system. So you can have the exact same trademark registered in Ohio and California because they're simply statewide. Okay? But once you get to the federal level, we're going to look to see, is there a mark in our register that is confusingly similar for related goods or services? And if so, at the federal level, we will not register that confusingly similar mark.
Thank you, Craig. Are you learning anything?